case.
Yes.
But we made any effort to see to it that we comply with our obligations towards this commission.
Yes,
and see to it that we are here.
Yes.
So thank you for allowing me
Yes.
to address you on this as introduction.
Yes, no, thank you.
Thank you.
And for maybe once you are back at your seat from where you think, I think it would be more convenient for you to address me, you could just for the sake of the record, just place the names on record, yourself, the instructing attorney, and of course, who you represent.
Indeed,
just for the record. Yeah.
Indeed, sir. Thank you so much, Chair. In view of what you said to me, for record purposes, I am Advocate Francois Roots, Counsel, representing Mr. Majola on instructions of Sali and Ishmael Incorporated from Best Valley, Johannesburg.
Thank you.
Thank you. My Lord, this is an application and we have filed a notice of motion. I know my instructing attorney of record made concerted efforts to endeavour to see to it that the necessary papers with the supporting affidavits and annexes thereto are presented to all the relevant parties as a matter of extreme urgency. In fact, late yesterday afternoon, I incessantly tried to get hold of him, saying that I need the papers, and I couldn't get through to him, and I later, around about 6 o'clock, only got through to him, and he had load shedding, and load shedding brought about that he could not operate whatsoever, and making calls and printing, etc., that goes along with it. And he also bumped his head, but be that as it may, this is an application to have the...
Did you ultimately choose to address me standing? Because I did allow you.
Yes, thank you so much. I will beg the indulgence to sit in the event that I cannot stand anymore.
Okay, all right, thank you.
This is indeed, as I've said, Mr. Chair, an application that the Chair considers that the matter that was enrolled for today, in respect of Mr. Majola, be deferred and that it be entertained on a later occasion. In the notice of motion, which is supported by the affidavit of my instructing attorney, Mr. Sali, he comprehensively deals with the efforts that have been made to procure the necessary information from Mr. Majola. I think it is clear from a reading of the papers, and I'll take you through it if you have not had the opportunity to read through it.
Well, I have had the opportunity to look at it. Ms. Hofmeyer was kind enough to make sure that after she received the notice of motion and affidavit last night, she sent it through. But you can obviously emphasize the important features of the application.
Yeah, I think we can expect nothing less of her, especially being who she is. The affidavit highlights the fact that concerted efforts were made to get hold of Mr. Majola. Sorry, may I just interpolate at this stage and see, I've got a bottle with me and no glasses. Yes. May I drink from the bottle, please?
Yes, that's fine, yeah.
And despite Mr. Sali having drafted whatever he could on what he had on the occasions that he could have spoken to Mr. Majola, it still appears that Dr. Pillay holds the view that Mr. Majola is not well. And perhaps it's Murphy's Law, the doctor himself, the psychiatrist, attracted COVID-19 and was indisposed himself for a number of days. So we were at pains to see to it that we are right and ready. We are fully aware of the importance of this commission and
maybe you
what the court has to do.
You might wish to put your beer bottle where it's flat, yeah.
And what the Commission and what Chair has to decide and the barrage and the plethora of information that you have to receive, and you cannot succumb to the whims of legal representatives or clients who are not seriously, who try and play games or do not really want to be serious in their presentation or not of their evidence. But I submit that it's clear, firstly, that we are not in a position, despite concerted efforts, to present to this Commission and to you, Chair, the comprehensive affidavit, which entails all that we have to say and in answer to the evidence that we received. But we can only do so if we are content, and you know much better than I do that we always have to act in the best interest of our client, that we have to have the okay of the psychiatrist stating that Mr. Majola is in such a position of health that he's able to allude to and advance a sensible, a well-informed, and a proper statement and facts to us, with a view to enabling us, as a matter of extreme urgency, to present the documentation we are obliged to do and we intend to do. So on that score, I will pray that you consider postponing this the matter today to a date suitable to you, Chair.
No, thank you. The matter that is of some concern to me, which I think you would have suspected would be of concern to me, is that I think it is the third time, if I'm not mistaken, when the Commission has fixed a date for Mr. Majola to come and appear, and he is unable to do so. And it would seem, if I read the papers correctly, it would seem that it seems to always happen just before the hearing, the date of his appearance. I may be misreading something, but that's the impression I get, and that's a little bit of concern to me.
I understand that, Chair. I, in fact, not only as a member of the High Court, but as counsel appearing, specifically dealt with this and with Mr. Sali. And I told him that under no circumstances must the impression be created that we are engaging in delaying tactics, or every time just before he has to testify there's some other reason for him not to decide what to do. As I say, as I understand, we do not need to file an affidavit beforehand, but we will indeed consider doing so. But I'm sure that you can rest assured that we've made it abundantly clear, and I'm sure Mr. Sali took much effort in alerting all parties that this will not be tolerated, especially by this Commission. And under the circumstances, I am bound by the instructions that I have. I also, initially, when I read these papers, had the same thoughts that you had. And the last thing ever is that I want the Chair to ever get the impression that we are playing games or embarking in delaying tactics or whatsoever. We know it's extremely expensive to have this Commission sit. We have the Deputy Chief Justice chairing, and we have our obligations. First and foremost, our allegiance is towards you, Mr. Chair, and then towards our client. So we will do everything, and I give you this as an undertaking as counsel, that we will do everything in our, which is possible, to ensure that we, as a matter of extreme urgency, obtain the information that we need, take a well-informed decision, and advise the parties accordingly. but I'm unfortunately bound by the documents that I have. I think my subjective belief, whether it's right or wrong, is irrelevant. I am bound by this, and I share your concern in this regard.
No, that's fine. I'll hear what Ms. Hofmeyer has to say. I am encouraged by the assurance you have given me as counsel.
Thank you.
That you will do everything in your power, together with your instructing attorney.
Thank you so much.
To make sure that there is proper cooperation from Mr. Majola.
Thank you.
As you know, the role of counsel and attorneys in matters such as this can go a long way to ensuring that there is proper cooperation from clients.
My Lord, Chair, for what it's worth, in all the years of practice, and I've been practicing for many, many years, I've had the privilege of being on the bench myself for 10 years as a regional magistrate. And I don't think it can ever be said that I ever deliberately or delayed any procedure whatsoever. I believe in that justice must be done, it must be done swift, and we must get over with it. Thank you so much.
Thank you very much. Thank you.
Thank you, Mr.
Thank you.
I profusely apologize.
Yes.
There was one aspect that slipped my mind, and that is I will beg the indulgence of the Chair to direct that his medical condition, that of Mr. Majola, be kept confidential.
Okay.
Thank you.
Thank you.
Thank you, Chair.
Yes, Ms. Hofmeyer.
Chair, as you indicated in your exchange with my learned friend, Mr. Roots, this is Mr. Majola's second formal postponement application. The first was received in February on the eve of his evidence. The second is the one moved today, again received on the eve of his evidence. And between those two applications, when he was scheduled to attend in May, when we were unduly optimistic that the Commission might be able to convene then, we also received confirmation that in advance of that evidence scheduling, he had again been admitted to hospital and was unavailable. So, Chair, your recollection that on 3 occasions anticipated evidence giving by Mr. Majola at this Commission has been preceded by admissions to hospital is not incorrect. Those are the facts. That's what we sit with today as you consider this application. Chair, that's an unfortunate state of affairs, I submit, because the evidence of Mr. X, who did give evidence and testify before this Commission, implicated Mr. Majola in large-scale looting of public funds while he was program manager at the Mhlatu's Water Board. According to Mr. X's evidence, Mr. Majola coordinated this scheme of looting, and he involved various established engineering firms in that scheme, and it was a scheme in which Mr. X was a participant by his own admission. The scheme, Chair, took money from the public purse that was intended for important projects, water projects in the area, and diverted it to private hands. Chair, Mr. X's allegations against Mr. Majola are very serious. And if true, They indicate nothing less than criminal conduct on the part of Mr. Majola. There is, I therefore submit, an intense public interest in this Commission receiving the version of Mr. Majola in response to Mr. X. Mr. Majola has been repeatedly invited since Mr. X's evidence in February to provide this Commission with his version on affidavit. Despite those numerous invitations and the almost 5 months since Mr. X's evidence, no affidavit has been forthcoming. Chair, it is not the case that in that 5-month period, at least from the facts that are disclosed in the affidavit, that Mr. Majola has been indisposed or in hospital. He has been for periods, as we understand the facts, but not consistently for that period. And although some effort has been made in the affidavit before you to describe the efforts that his legal team has taken to prepare that affidavit, it is so that lawyers all around the country, under COVID circumstances and otherwise, have managed to take instructions from clients to prepare affidavits, to convene virtual meetings, and indeed to run cases before courts. It is therefore in our submission inexplicable, in fact, how the Commission could be almost 5 months from the evidence of Mr. X and not have Mr. Majola's version even on affidavit before it. Chair, in the light of that situation, it is our submission that the postponement application should be addressed in the following terms. Chair, we submit first that as a practical matter, Mr. Majola is not present today. As a practical matter, we simply can't proceed with his evidence. He remains in Durban, as I understand it, waiting for a bed at a hospital at which he's been admitted by his physician. There is, as a consequence, no way in which we can practically proceed today. And so, to the extent that that is not feasible, we submit the application should be granted. But, Chair, we would like to submit to you that it should not be granted without something more. And the something more, Chair, is that we stipulate, and you in your ruling do so, the requirement that Mr. Majola does provide his affidavit, his version to this Commission. I propose a reasonable amount of time. I don't have a sense of the details, but something of the order of 4 weeks I was going to submit to you might be reasonable. On my count, that would take us to the 12th of August, 2020. Chair, my learned friend in his submissions to you earlier said he understood that affidavits were voluntary and not necessarily compelled. Well, of course, Chair, you have the power under the regulations to issue a directive, a 10-6 directive, which not only makes it obligatory to provide an affidavit, but the person who fails to provide the affidavit now, because of the amendment to the regs, commits a criminal offence, in fact. We submit in any ruling you give today, you should simply stipulate that the affidavit is required, that it should deal in detail and comprehensively with the evidence of Mr. X, both in the affidavit version he presented to the Commission, but also the transcript of his oral evidence, and that should be provided. I submit a reasonable time might be in the order of 4 weeks. And Chair, once the Commission has received that affidavit, of course it can be considered and further steps can be taken, including summonsing Mr. Majola if that is necessary. Chair, those are our submissions in relation to the application.
Are there specific questions that have been given to Mr. Majola to address in an affidavit form?
Chair, there were in advance of Mr. X's evidence.
Yes.
Because there were engagements with Mr. Majola and Mr. X in advance of the February evidence. At that point, Mr. Majola refused to engage with the Commission and did not provide answers to those questions. Since Mr. X's evidence itself and his comprehensive affidavit, there has not been a follow-up with additional questions, but that is something that we could certainly facilitate.
I'm thinking that counsel here and his instructing attorney would probably make it very clear to Mr. Majola that he should provide an affidavit and should answer those questions. I believe that they would play that role. So I would be inclined to include in the order an order that he should furnish an affidavit giving his version and specifically answering the questions that have been put to him by a certain date. As you stand there, are you satisfied that those questions that were previously sent to him are still fine? There is no need for any amendment because obviously he has possession of those, and so I can just make an order that those questions are still valid, so to speak.
Chair, let me correct one aspect. We never actually send questions per se, so
yes.
it would just be a wrong characterization.
It's topics, yeah.
It's topics,
It's
indeed.
topics, yeah.
So from the first engagement, the
Yeah.
general topics have been canvassed.
Yeah, to say, give your version on these
On
topics.
these
Yes, okay.
events or topics,
good
etc.
enough. That's good enough.
Having said that, though, that happened early on in the investigation, and certainly by the time of Mr. X's evidence, Mr. X's account of events had filled out quite substantially.
Yes.
There wasn't then a further return to Mr. Majola to say,
Yes.
well, now there's a fuller version, because the fuller version then came in Mr. X's affidavit
Yes.
and in his testimony.
Yes.
So as I stand here today, I would suggest the original topics remain valid.
Yes.
But what is most critical is that the affidavit that is produced by Mr. Majola addresses all the respects in which Mr. X's evidence implicates him,
Yes.
refers to him. He can give whatever background and
Yeah.
context he needs to give
Yes.
his version fully.
Yes.
But the focus, I submit, should be on Mr. X's evidence, because that is the latest iteration of the investigation.
Yes. Yes.
And would offer Mr. Majola, I submit, the fullest opportunity to make sure that nothing is left unanswered in Mr. X's version.
Does he have the transcript of Mr. X's evidence, or does he only have the affidavit?
He certainly has the affidavit. The transcript is available on the website.
Yes.
So it's just a matter of a click, and I'd be happy to provide the link later
Yes.
today to my learned friends.
Yes. Okay. All right. Thank you.
Thank you, Chair.
Thank you. Counsel, you can address me from there if you wish, but if you want to go to the podium, that's fine.
Mr. Chair, I totally align myself with the submissions advanced by my learned friend behind me.
Ms. Hofmeyer, yes.
And the court, at the risk of being repetitive, repeat that we will do our utmost
Yes.
and see to it
Yes.
that those questions be answered to the
Yes.
fullest extent that we are able to.
Yes.
And moreover,
Yes.
I just want to place on the record that my instructing attorney advised me that he has in fact received the evidence of Mr. X,
Yes, the affidavit.
the affidavit,
Oh, no, the
evidence.
transcript. The
the
transcript.
transcript of the evidence of
Yes,
Mr. X.
oh, excellent. That's good. Yeah,
Thank you,
that's
Mr.
good.
Chair.
In terms of time frame for the affidavit, I think the doctor said he might be in hospital, that is Mr. Majola might be in hospital for a few weeks or 2 weeks. In terms of the time frame for the filing of that affidavit, what do you, I mean, obviously Mr. X has had ample time in the past 5 months to do so, but while he's in hospital, he can't do anything.
Chair, we'll have to get the guidance, of course, of the doctor who treats him, but we will truly tell the doctor how urgent this matter is and what your
Yes.
sentiments are in this regard.
Yes, yes.
And there's
yes.
no time to be wasted, even if we have to burn the candle at both ends.
Yes, yes.
So,
So maybe I could, we could look at the 15th of August. I don't know what day of the week
15th
is.
of August, 15th
On
of
or
August.
before 15 August. And if for some reason, through unforeseen circumstances, there is a real difficulty, then you can apply for an extension. But obviously, you understand very clearly what my
Your attitude is just, Chair.
yeah.
Thank you so much.
Okay, no, thank
so
you very much. Thank you very much.
Thank you, Chair. Just one point
Yes.
of correction. It might have been my inaudibility with the mask, but
Yes.
the 15th of August is in fact a Saturday. So I think
No,
4 weeks...
I don't think it's your fault. I think you said 12.
Yes, I did.
But
I
I thought we are on 15 July,
Yes, so
1
we
month.
just added the
15
month,
yeah,
exactly.
yeah.
Well,
Okay.
Chair, the 12th is the Wednesday of the
Yes.
week, which is exactly 4 weeks from today. But if we were to make it the Friday, the 14th, it
Yeah,
seems immaterial
yeah,
to me.
yeah, I think
Just
that-
the 15th is a
Yeah.
Saturday, so
No, that's fine.
thank you.
Actually, 30 days would expire on the 14th.
Indeed,
Yeah.
indeed.
Okay, thank you.
Thank you, Chair.
The application for the postponement of Mr. Majola's, for the postponement of the hearing of Mr. Majola's evidence is postponed sine die, that is 1. 2, Mr. Majola is directed to deliver an affidavit on or before the 14th of August 2020, in which he deals with the topics that have previously been furnished to him and gives his full version on those topics with regard to the evidence given by Mr. X before this commission earlier this year. I think that covers everything, I think.
Indeed. Thank you, Chair.
Okay, thank you very much. And thank you to counsel and his instructing attorney for their determination to try and make sure that Mr. Majola will cooperate in making sure that we don't have these further postponements in the future, if at all possible. We adjourn.
Thank you.
Thank you.